Now go to page 2 of the 8 pages in your packet. The very first paragraph, we talk about the bankruptcy estate. The bankruptcy estate is created, a bankruptcy estate is created whenever any person, any company, or any political unit files bankruptcy. The bankruptcy estate is a snapshot picture of what you have, own, or have a right to at the moment that you filed your bankruptcy case. Your bankruptcy estate includes every legal or equitable right that you have in any property, claim, or option anywhere. For example, a claim for a tax refund would be part of your bankruptcy estate. Each debtor, therefore you, must file a list of all bankruptcy estate items and their value with the bankruptcy court. We prepare those in the form of pleadings. D, each person who files then selects and keeps their exempt property as set forth in the bankruptcy law and other federal and state laws. E, non-exempt property, the property that is not exempt, if any, and in 98% of the cases there is no such thing as non-exempt property, everything is exempt. But if there is any non-exempt property, this is sold usually to the debtor by the court, and the money that is raised by selling it to the debtor or to whoever it may be, this money is paid to your creditors. You no longer own any non-exempt property when you file your bankruptcy case. Take a look at paragraph 2. Now these are the social safety net. You get to keep all of these things. That you keep, for example, Social Security, unemployment compensation, local public assistance, veterans benefits, disability benefits, unemployment benefits, alimony, support, or separate maintenance to the extent necessary for the support of the debtor or a dependent of the debtor, payments made under a stock, bonus, pension, profit sharing, annuity, and similar plan or contract paid because of illness, disability, death, age, and length of service. That's a lot to be said there. But what it is all of your social safety nets are taken care of. You don't lose any of them simply by filing bankruptcy. Number 3, you can also keep or exempt your home or the mobile home and a mobile home lot if it's your home for you or your dependents. A, make sure you write in the address of the home that you want to keep. And then B, you must continue your payments on your mortgage, taxes, insurance, and homeowners association unless you're going to give up the home, then you don't want to do that. But if you're going to keep them, keep those payments current. Number 4 there, yes or no. Do you want to keep the home? Just yes or no. And then C and D, what year did you buy this home, and who pays the property taxes, you or your mortgage payment. And go through all of number 4 there, the next one, list the approximate fair market value of the home as it is today. And then number 5, list all of those. And 6, complete those by the yes or no's or complete the information that applies there. Number 7 is spaces there for you to provide information on any other real estate that you may own or have a right to. If someone is paying you a mortgage, then you have an interest in that property, you have to put it here. If you own rental property, you have to put it here too. Number 9 lists a number of other things that you get to keep: annuities, educational IRAs, lump sum alimony, workman's comp, and again, the tax-exempt kind of items that I referenced above. Number 9, you can keep or exempt the following personal property, but this is in very limited amounts. Beware and be careful. This is not very much. You get to keep $1,000 per debtor of equity in any one automobile. So if you have the $150,000 Maserati, and I know you need it for work, and you owe no money on it, that's in excess of your $1,000 exemption. That would pass to the bankruptcy court. But most of the cases are, $10,000 on a $5,000 vehicle, or $7,000 vehicle, or $8,000 vehicle. No problem. If it's $10,000 owed on a $10,000 vehicle, fine. If it's $11,000 vehicle, you're fine. But you have to list all of your vehicles there. And you get 9B says each debtor gets to keep $1,000 of equity in personal property and claims that you have against others. IRS, I have a claim against the IRS for a refund. Now, if you're not claiming a home, look at C. You get an additional $4,000 per debtor in personal property and vehicles if you do not claim a home as exempt. You can claim up to $4,000 per debtor by not exempting the home, but you cannot claim $4,000 per debtor exempt if you owe any money to anyone under a domestic support obligation, alimony, child support, those kind of items. If you owe money, you're disqualified from claiming this additional $4,000. So your $1,000 stays at $1,000. It doesn't grow to $5,000 if you owe that kind of money. The next one, you can also exempt out property which you owe more than its actual value. Again, the vehicle, you owe more than what it's worth, you get to keep that vehicle. Jointly owned husband and wife property can also be exempt. In Florida, there would be, if your husband or wife files, there'd be the husband's property, the wife's property, our property. Husband files, has to list his property and our property, not her property, and then the jointly owned property is exempt. If it's the wife who's filing, she has to list her stuff, our stuff, but not his stuff if he's not filing. If both file, you have to list the husband's property, the wife's property, and our property. That's the problem that you have there. When you get down to paragraph 10, we start listing the kind of things that we need to be concerned about. A, cash on hand, the amount of money you expect to have on hand on the day you file bankruptcy. And number 2, all of your bank accounts that are still open when you file bankruptcy. Obviously, if you close out bank accounts, you don't have any money in them. You have to have all the accounts there and how much money you have there. And at the very bottom, deposits with landlord, telephone company, utilities, others, and the total that you have there.